of the Immigration and Public Law team. Thank you for joining us. We're now almost halfway through our webinar series for spring 2021. And I think our prediction was correct, because I think it has helped to bring about slightly warmer weather and a bit of sunshine. So welcome again. I'm really pleased to be chairing the session today. I think we've got some exciting talks, some expert speakers, and Luke de Noronah is joining us as well in the middle of the webinar. So welcome, and we will first start with Sara Anzani, my colleague in the team, who will be speaking, as you can see on the screen, on unduly harsh tests and other key concepts in criminal deportations. We will then have our colleague Jamil Dhanji, who will be specifically looking at the concept of homegrown criminals. We will then pause with some slides and have Luke and more of a conversation with him about his book, Deporting Black Britons. And then towards the end of the webinar, we hope to have our colleague Lawrence Yousefian, who will be speaking about delay and how that may impact criminal deportations and how that perhaps can be used to fight against those. But I do say I hope, because sadly for us, Lawrence has been delayed in court, so he hopes to be able to finish in time, but we'll just have to keep an eye on that. And if he doesn't, then we will just postpone that part of the webinar and host a further webinar on criminal deportations later on in the series. So don't worry, as that topic will be available then. So the last matter that I wanted to highlight in housekeeping is just that these slides will be made available when after the webinar and when the recording is also finalised. So that will be uploaded, and you will receive that through the Eventbrite emails as soon as it is ready. We anticipate probably on Monday, no later than that. So without further ado, I'm going to hand over to Sarah to start the first talk of this session.
Thank you, Sarah, and thank you everybody for joining us today. So I'm going to be taking us through three notable Court of Appeal decisions from the last 6 months that have revisited the unduly harsh test in respect of those facing deportation. And when we talk about the unduly harsh test, obviously we're looking at section 117C of the Nationality, Immigration and Asylum Act, which makes specific provision in relation to the consideration of Article 8 in cases concerning the deportation of foreign criminals. So far as is relevant for today's purposes, the provisions of section 117C state that the deportation of foreign criminals is in the public interest. The more serious the offence, the greater the public interest in deportation. And for those sentenced to periods of imprisonment of under 4 years, the public interest requires deportation unless exceptions 1 or 2 apply. You can see from the slides, exception 2 has been set out, and that says that where the deportee has a genuine subsisting relationship with the qualifying partner, or a genuine and subsisting parental relationship with a qualifying child, and the effect of deportation on the partner or child would be unduly harsh. And that's replicated then within paragraph 399A and B of the immigration rules. So until September 2020, the authoritative guidance on what is meant by unduly harsh was that given by Lord Carnwath in the Supreme Court decision of KO, Nigeria. At paragraph 23 of that judgment, he said that the expression unduly harsh seems clearly intended to introduce a higher hurdle than that of reasonableness under section 117B6. Further, the word unduly implies an element of comparison. It assumes that there is a due level of harshness. That is a level which may be acceptable or justifiable in the relevant context. Unduly implies something going beyond that level. He said of note that one is looking for a degree of harshness going beyond what would necessarily be involved for any child faced with the deportation of a parent. Thankfully, in the last 6 months, there has, as I've said, been a welcome revisiting of this issue. Firstly, on the 4th of September 2020, the Court of Appeal handed down judgment in HA, Iraq. It's a substantial decision. It contains far-reaching and important analysis of a number of different aspects, actually, of UK deportation law. But specifically, it looks at the unduly harsh test as formulated in KO. You can see from the slides that I've set out a very brief overview of the procedural history and the facts in the case. In a nutshell, there were two appellants, both Iraqi citizens, HA and RA, and both had British children. In the case of RA, his appeal before the upper tribunal had resulted in the reported decision of RA, Iraq in 2019. And in terms of the offences, HA had received 16 months imprisonment for immigration offences and RA 12 months for ID offences. Both had won their respective appeals against deportation orders before the first tier tribunal. And in both cases, the Secretary of State appealed to the upper tribunal. Errors of law were found, and the Secretary of State succeeded in the appeal. Lord Justice Underhill then granted permission to the Court of Appeal so that the court could primarily consider the guidance given by the upper tribunal on the issues of general application. A significant portion of HA is dedicated to trying to work out what, in fact, Lord Cornwall in KO had meant. And Lord Justice Underhill starts by reminding us at paragraph 40 of HA that the actual issue in KO had been a very specific one, and that being whether the word unduly had referred back to subsection 2 of section 117C, and so required a balancing of the relative seriousness of the offence. That question had been the subject of conflicting decisions both in the upper tribunal and in the Court of Appeal. Of course, we know that there was a move beyond that, with Lord Conworth then going on to express his view as to the height of the threshold of the phrase unduly harsh. But Underhill reminds us in HA that that was actually not his primary focus. So the key passage to have a look at in HA is paragraph 44, firstly, and Underhill there states that in order to establish that the word unduly was not directed to the relative seriousness issue, it was necessary for Lord Conworth to say to what it was in fact directed. That's what he does in the first part of the paragraph. The effect of what he says is that unduly is directed to the degree of harshness required. Some level of harshness is to be regarded as acceptable or justifiable in the context of the public interest in deportation of foreign criminals. What unduly does is to provide that exception 2 will only apply where the harshness goes beyond that level. Lord Conworth's focus is not primarily on how to define the acceptable level of harshness. It's true that he refers to a degree of harshness, quote, going beyond what would necessarily be involved for any child faced with the deportation of a parent. But that cannot be read entirely literally. It's hard to see how one would define the level of harshness that would, quote, necessarily be suffered by any child. Indeed, one can imagine unusual cases where the deportation of a parent would not be harsh for the child at all, even where there was a genuine and subsisting relationship. The underlying concept is clearly of an enhanced degree of harshness sufficient to outweigh the public interest in the deportation of foreign criminals in the medium offender category. So what then is the correct test? Well, having considered KO in forensic detail, Lord Justice Underhill concludes that the essential points of the test are as follows: that the criterion of undue harshness sets a bar which is elevated. It carries a much stronger emphasis than undesirability. The reason why some degree of harshness is acceptable is that there is a strong public interest in the deportation of foreign criminals, including medium offenders. The underlying question, he says, for tribunals is whether the harshness with which the deportation will cause for the partner or child is a sufficiently elevated degree to outweigh that public interest. But importantly, he stresses that there is no reason in principle why cases of undue harshness may not occur quite commonly, and that's at paragraph 56, an important point to note. So what Lord Justice Underhill is making clear is that how a child will be affected in that paragraph, he also says, it will depend on an infinitely variable range of circumstances, and it's not possible to identify a baseline of ordinariness. So it's important to remember when preparing representations and appeals that there are, as is said in HA, an infinitely variable range of circumstances specific to your client's case that might make the degree of harshness on your client's partner or their children or child such that the public interest in deportation is outweighed. It's important always not to think too prescriptively. Some of the obvious examples of factors that might, however, impact upon the degree of harshness that you might wish to consider are those outlined in the slide. So the child's age, whether a parent lives with them at the time or previously, although Underhill was at pains to stress that a divorced or separated father may still have a genuine and subsisting relationship with a child who lives with the other parent. The degree of the child's emotional dependence on the parent is going to be relevant, the financial consequences of the parent's deportation, availability of emotional and financial support from either the remaining parent or other family members here in the UK, the practicality of maintaining the relationship with the deported parent following removal, and obviously also the various individual characteristics of the child in question. In the next slide, I've highlighted some other important points to note from the judgment, and you can obviously consider those in your own time, but one part of the judgment I would particularly like to highlight is that of Lord Justice Jackson at paragraphs 151 to 163, where he is looking at section 55 considerations and the best interests of the child. I'm pushed for time, and so I won't go into too much detail, but he talks there about the way in which we generally approach physical harm as being intrinsically more significant than emotional harm, and where one falls into error in essence in doing that. There's some really helpful bits of guidance that's provided for there that I'm sure you'll find useful when preparing cases going forward. So please do go and have a look at that. So the takeaways from HA, we can see that the Court of Appeal, thankfully, are restoring here a more flexible and child-centred approach to the unduly harsh test, which frankly is a welcome move. There's a notable departure from the preoccupation that we've had over the last few years about the height of the unduly harsh threshold, which had until recently precluded ordinary levels of hardship from meeting that threshold. And then we move on to the two more recent decisions in AA Nigeria and KB Jamaica. Again, two Court of Appeal judgments that followed in close succession towards the end of last year, both of which endorsed and applied HA Iraq. In both cases, it was Lord Justice Popplewell giving leading judgment. And similarly to the situation in HA, both AA and KB had succeeded in their appeals before the first tier. The upper tribunal, following appeals from the Secretary of State, found there to be errors of law in those decisions and remade and dismissed the appeals. Aside from the Court of Appeal being critical of the over-enthusiastic use of the upper tribunal's error of law jurisdiction, they also made a number of other points that will be of interest. Firstly, reiteration again of the danger of trying to identify an ordinary level of harshness, a resounding approval in both of the decision in HA Iraq. In AA at paragraph 40, broadly helpful comments on rehabilitation. In KB at paragraph 33, reference to the loss of a role model being a legitimate consideration when looking at whether or not removal of a parent would be unduly harsh. So again, go away and have a look at those particular paragraphs. And then lastly, to round off, I just wanted to also highlight paragraph 9 of AA, and this is in relation to citing relevant authorities. There had been a lamenting of the proliferation of case law in AA, particularly in relation to the unduly harsh and very compelling circumstances tests, which led Lord Justice Popplewell to try to distill the relevant authorities down to 4. In relation to unduly harsh, he said the only 2 authorities really relevant will be KO Nigeria and HA Iraq. And in terms of very compelling circumstances, are on the application of bin loss and then NA Pakistan. Obviously bear that in mind when preparing bundles and making representations, etc. You might also want to cite AA Nigeria and KB Jamaica in terms of restatements of HA Iraq, if you consider that to be helpful or appropriate. And that brings me to the end of my presentation. At that point, I will hand over to Jamil.
Thanks, Sarah. And I'm going to change tack. In the time allotted to me, I want to try and just briefly explore a question, which really is about the relevance of the fact that a potential deportee has lived in the UK since childhood to the issue of the proportionality of his or her deportation. And I want to try and explore the answer to that question by looking at some recent cases. Now, I should probably flag up before I begin, there are quite a few cases to get through, so I'll do my best to get through all of them. And I'm very conscious that the way that we answer this question in appeals is really going to depend on whether the potential deportee had lived in the UK lawfully for more than half of his or her life, and also the length of sentence that they received, because one can look at the question through the prism of section 117C subsection 4 and exception 1, or we can look at it through the prism of very compelling circumstances over and above. I'm going to try and identify just some general legal principles rather than get bogged down into the detail. And the starting point is the case of Bin Booga. You would have seen, obviously, that my part of the talk refers to homegrown criminals, and I've used that phrase quite glibly. But the reason is because that phrase has found its way into a number of cases. And the first or the most recent time that the phrase was used was in the case of Bin Booga. Mr. Bin Booga had come to the UK when he was 9 years old. He'd had some petty offending before he was 18. And then in his 20s, he'd been convicted of burglary and been given 12 months in prison. The Home Office sought his deportation. He won in the first tier. The upper tribunal overturned the decision, and then we find ourselves in the Court of Appeal. And the first tier judge had based his decision to allow the appeal on a number of factors, but one of them was this factor here, that he saw Mr. Bin Booga as being a homegrown criminal. And he said that homegrown criminals such as Mr. Bin Booga, who had spent most of their childhood in the UK, that fact is something that could outweigh the public interest in his deportation. And Lord Justice Hampden really rejected the use of this phrase, homegrown criminal. In fact, he went on to say that it's a phrase that cannot withstand analysis, that it's an unhelpful description, and that it's liable to mislead. And in doing so, he endorsed some other comments that had been made in the Court of Appeal in a case called LW Jamaica, where it had been said that the phrase homegrown criminal has an attractive ring to it, but it cannot survive analysis. And I remember reading the case of Bin Booga and thinking to myself that the court's approach couldn't be right, particularly when one moves on to see how Lord Justice Hampden approached something that had been said earlier in the case of HK Turkey. Because in HK Turkey, Lord Justice Sedley had made a point that in my opinion is a really, really important point. 15 years spent here as an adult are not the same as 15 years spent here as a child. And the difference between somebody who's an adult that comes here and spends 15 years here, or somebody that comes here as a child, could be the difference between enforced return and exile. Whether we agree with the terminology homegrown criminal or not, what it stands for, in my opinion, it is a concept that is very much relevant to deportation cases. And that's what Lord Justice Sedley had said in HK Turkey. but Lord Justice Hamblin distanced the court from those observations and has basically laid down the marker that the phrase homegrown criminal, homegrown offender is inappropriate. So that leaves us in a position perhaps where we think that it's not relevant that somebody may have lived in the UK since childhood and is now facing deportation. But then we move on to some other Court of Appeal cases where I think we've seen a real movement away from the position adopted by Lord Justice Hamblin. So let's start with the case of Akinyemi. Mr. Akinyemi was born in the UK, in fact. He was a Nigerian national who had indefinite leave to remain, and he was entitled to apply for British citizenship, but he never did. He accrued a lot of convictions. I think he got 20 convictions for 42 offences. And he found himself facing deportation. The most serious offence he had was led to him getting a 3.5-year term of imprisonment for possession of heroin with the intent to supply. He won in the first tier. And again, we find ourselves then in the Court of Appeal. And what the appellant was trying to argue in the Court of Appeal was the fact that he'd been born in the UK, the fact that he'd spent his entire life here, was something that should weigh upon the public interest, that should effectively reduce the public interest in his deportation. Because what he was facing was exile from the only country that he could call home. And the court agreed. In this case, on the facts of this case, the court agreed. And what they said is something that we've probably all been using in appeals for the last year. The public interest in deportation has a movable quality. It's not something that's fixed. And one of the factors that can move, that can reduce the public interest, is where somebody has lived in the UK for their whole lives. And I think one can stretch that, has lived in the UK for the majority of their lives. And although Sir Ernest Ryder made it clear that cases of this nature, where one can outweigh the public interest due to the length of one's residence in the UK, will necessarily be very few, what the judge has to do is actually consider the effect of the length of residence on the question of the weight to be attached to the public interest. And also just note the use of the language. We're talking here about exile. So we can't use phrases like homegrown offenders, but we can use phrases like exile. And you'll see that as we move through the slides, through other cases, the kind of language that's being used by the Court of Appeal is very interesting. We have then got the case of CI Nigeria. CI was born in Nigeria. He came to the UK when he was 15 months old. He was an overstayer until he was 15 or 16 years old, and then he got indefinite leave to remain. But by the time he came before the courts, he hadn't lived in the UK for most of his life lawfully. He had been given 43 months imprisonment, and he again finds himself in front of the Court of Appeal. And the judgment is interesting in my opinion, for 3 reasons. Because what the upper tribunal had found in dismissing CI's appeal was that despite the fact that he'd been in the UK since he was 15 months old, his offending had broken his social and cultural integration in the UK, that had served to sever that. So they found that he wasn't integrated. And the Court of Appeal, whilst finding that in certain cases offending can break integration, can break the integrative links that an individual has with the UK, in this case, there was an air of unreality about the upper tribunal's judgment. The second point that was made in CI was that for some individuals who have been in the UK since a very young age, that they won't have ties to their home country. And the Court of Appeal adopted the words that were used by CI's sister in the case, in the appeal before the first here, which was that to CI, Nigeria was as foreign to him as China. Again, very interesting that the Court of Appeal is actually adopting those words. But the point here is that for some individuals that are being told that they have to return to the country of their nationality, they may not have any ties whatsoever with those countries. Those countries may be foreign to them. And finally, the court endorsed the principles in Maslov. I'm sure that anyone that's been following deportation cases over the last 5 years or so have seen that Maslov principles have been battered back and forth. This is the most recent Court of Appeal case that says, of course, Maslov is relevant to the question of proportionality. And therefore, we're still looking at the same factors and considerations that we've always been looking at. So things like an individual's ties to this country or lack of ties to his country of nationality. We then move on to the case of Lowe. And I talk about language, but before we look at exactly what Lord Justice McComb said, Mr. Lowe was a 3-year-old Jamaican when he came to the UK, and he'd lived here obviously ever since. He got 2 years, 4 months for drug and knife offences, and he won his appeal. And sorry, those offences were committed when he was 17 years old. He won his appeal in the first tier tribunal. Upper tribunal overturned the decision, and we find ourselves in the Court of Appeal again. The upper tribunal had overturned the first tier's decision on rationality grounds, and this is what Lord Justice McComb had to say about the upper tribunal's decision. And again, just look at the language that's being used. He's talking about the effect of the exile of this young man, and he's referring to his Jamaican nationality as being a residual nationality, talking about him being dumped in Jamaica at the end of his prison term. Although Lord Justice McComb wasn't considering the merits of this appeal for himself, it's clear, in my opinion, what he thought of the upper tribunal's decision to overturn what the first tier had found. And in fact, you may have seen this is the judgment where there's a lot of criticism of the upper tribunal just overturning decisions at the error of law stage. And they make the point that the first tier process is not a dress rehearsal, that that's where the decision should really be reached properly, and that we shouldn't be going to the upper tier routinely in deportation cases to have them overturned. But then again, you can see the flip side of that, which is the case of Zulfiqar. Now, the facts of Zulfiqar are very interesting because Mr. Zulfiqar was a dual British-Pakistani citizen. He was born here. He was convicted of murder in 2004. And in 2008, he tried to be repatriated to Pakistan. That request was refused. So in 2011, he renounced his British citizenship to try and get repatriated, but that again was refused. So he finds himself in 2019 facing deportation. He tried to challenge the deportation, but his appeal was dismissed in the first tier. And then he goes to the upper tier and tries to overturn the first tier's decision. Now, he ran rationality grounds, so he argued that the first tier's decision was irrational. And the upper tribunal disagreed. They maintained the decision. And one of the factors that they cited was the fact that Pakistan was not a country that was entirely unfamiliar to Mr. Zulfiqar. So just by a quick rush through all of those cases, I think we can actually draw out some important principles. And to answer the question I asked at the beginning, really, the answer is, in my opinion, that it's incredibly relevant if somebody has been in the UK since childhood and is now facing deportation. It's helpful when arguing the case if some of that residence had been lawful. Of course, if most of that residence had been lawful, then that's very helpful because it can potentially bring you in within one of the exceptions. But there is case law, particularly recent case law from the Court of Appeal, that we can use to argue that it's relevant to the question of the strength of the public interest in that person's deportation. But what you can see from the cases is essentially judges have a very, very wide discretion when it comes to determining how strong the public interest is. So I think we need to make sure that these arguments are being pleaded, at the first tier, because the first tier is not a dress rehearsal. And we should still be using case law like Maslov and HK Turkey, alongside the case law that I've tried to rush through today, in pointing out why people that are born here or people that have been here from a very young age that are facing deportation shouldn't be deported. So with that in mind, I think I've set up for the next part, and I'll pass back to Sarah.
Thank you, Jamil, and thank you, Sarah, for both of your presentations. Not an easy feat, again, in terms of covering so much in quite a squashed time, and I'm afraid you have got us to blame by limiting your time. So I'm grateful to both of you. So now we pause on slides, and we are joined by Luke. Before we turn to Luke, I just want to update that it looks like Lawrence won't be able to join us. So unless his case concludes very, very quickly in the next 20 minutes or so, it's unlikely, but I will keep on updating you as we go along. But yeah, we turn to Luke. So thank you, Luke, for joining us. If you don't mind, I'm going to try and give you a an intro that is worthy of your work, and so I hope I will manage that, and do forgive me if I don't. But Luke, for those who may be less familiar with Luke and his work, is an academic and writer working at the University currently of Manchester. He has written widely on the politics of immigration, racism and deportation, and he has also produced a podcast called Deportation Discs, Desert Island Discs, if you will, with deportees in Jamaica. And shortly I will post the link to that. It's definitely comes highly recommended, certainly from me. And the last podcast dropped, I think, on the 1st of February. So again, very current. But we're here today, as mentioned and as advertised, to talk about your book, Deporting Black Britons. If we have time, we may also try and touch on your new publication that you contributed to, Empire's Endgame, Racism and the British State. But let's see how much time and how ambitious we can be. Again, for the chat box, watch out, I will post a discount code that was very kindly shared by Luke and the publishing house for Deporting Black Britons, giving 30%. I've also got, if you bear with me, my copy here. So really comes highly recommended. So do look into that if you haven't already. But Luke, thank you again, as I said, for joining us. Starting off perhaps with the term Black Britons, we've obviously just heard Jamil's talk covering the concept that has been termed by the courts in this country, homegrown criminals. Black Britons is the term that you use to describe those who came to the UK as children, young in their childhood, and who have either been deported or perhaps face deportation action as adults. It's something that certainly resonates with immigration lawyers in this field. And as mentioned, we've just heard Jamil talk about that concept in the courts and its evolution. What's your view in terms of hearing in particular Jamil's talk of how the courts are grappling with that, if you, from your perspective as a writer, as an academic who's studied this?
Yeah, thank you. Thanks for having me. I really enjoyed both of those presentations, and I like trying to get stuck in as a sort of amateur lay person engaging with the law. Just to say quickly, I'm not at Manchester anymore. I'm now at UCL. I only say that not because I'm precious about those things, but because I'm working at the Sarah Parker Riemann Centre, which might be interesting to people in London because it's going to be a new space for questions around race and racism. A few things that came up for me. I mean, I think the label homegrown criminal being said by judges and exile being used by judges is really interesting, because I'm trying to make these kinds of points by blurring the legal and the lived when it comes to belonging. So, you know, legally one might be foreign, and I think Jamil deliberately made the point of saying the country of your nationality or your country of citizenship rather than your home country, because these questions are blurred. So it strikes me that some of the guys would probably quite like the phrase homegrown criminal, because some of them said things like, you know, England made me a criminal, or I was basically a normal black guy in Britain, or whatever it might be. That would really resonate with them. This question of integration is something I mean, I really appreciate you mentioning the more recent book, but the Deporting Black Britons book is the one that has the closest kind of connection to this conversation today, in one of the chapters. In two of the chapters, I talk about legal files that I got to look at. And the question of integration is kind of central to one of them, because the thing I find interesting, I suppose, is that sometimes, not always, and I think judges really vary on this from the determinations I've read, whether they think someone's integrated or not, and whether criminality can affect that. Some seem to say they've been here for this long, therefore they've integrated, and others seem to say their criminality is a mark of their lack of integration, which is just interesting, because integration is already, I mean, as kind of anti-racist scholars have called it, a political problem, where we get to, where basically it's apparently about liberal values of cohesion and citizenship, but really it's about what we do with them. When it comes to questions of integration, a way of rewriting assimilation really as something more, apparently more open, but really tends to be around the question of Muslims and around the question of people involved in crime in the case of deport cases. So I'm interested in how integration here means good citizenship. It means abiding by the law, having money to support your children, often cohabiting, having the children only with one partner at one time, for example, and abiding by the law, most importantly. Whereas integration in the context of whether you'll be able to integrate in your country of your citizenship tends to mean a very low bar of whether you'll survive. So it's interesting for me to as doing expert witness reports and stuff, to see the integration here means something like being a good stand-up citizen, and integration there means something like, oh, they'll be fine because the language is English, or they'll be fine because their family were Jamaican, so he grew up knowing the culture and customs, which you have read all this stuff, but I think it's interesting to think about integration in the country here, in the country of citizenship. So that struck me as interesting. And yeah, I suppose just to say the point about Black Britons is to precisely open up that provocation and question about legal citizenship and about the way people feel that they belong. But it's also to fasten on the study of deportation or the study of immigration control to a longer conversation about Black Britain. And I think the Windrush Scandal did that. I think people started talking about migration and waves of migration and Britain's colonial past and what Black presence or former colonial presence meant in this country and where we are now. And I think that's been the thing for a long while, is to talk about the history of Black Britain, the history of post-war migration, and by kind of putting in the figure of the deportee now living in exile. That unsettles some of that story about this idea of waves of settlement, and then the tension is really only played out. I felt that the way people who study race and race relations in the UK imagine Black Britain or Asian Britain is that you have successive waves of migration and then their children, or rather you don't have successive waves necessarily. You have the Windrush generation and their children and their children and their children, whereas from the perspective of migration you have political and legal contestation over who has what rights, who can move in what ways, who can settle, and whose stay is revocable, and of course questions around people being deported who are born here or citizenship stripping bring all of that up as well. But I think the question of Black Britain and of Black Britons is complicated when you think about legal status, something lawyers know, but I don't know if kind of cultural conversations about race and racism in this country, I don't think they take legal status or the possibility of deportation front and center. And I think they'll increasingly have to, given the young people do know about this and do face their friends having precarious status, not being able to go to university, or in some cases facing detention.
Yeah, absolutely. And you mentioned the Windrush Scandal, and I just wanted to ask you a bit more about that, and perhaps how it has helped, perhaps if it has, in terms of raising awareness on how deportation can affect Black Britons. Before I turn to you, I just wanted to lay the mark that your project that led to your book, Deporting Black Britons, did start quite a long time, I think, right? Before the Windrush Scandal was, I don't want to use the term discovered because it's always there, but it did arise through Amelia Gentleman's work as published in The Guardian and so forth. So why is it important that you were looking at that before then, and also perhaps how has Windrush Scandal and all of that that's entailed helped these issues?
Yeah, it's a good question. I mean, to start with to start with my own work, I didn't come to this out of the Windrush moment, which is where a lot of people first started thinking about Black Britons and deportation. I came to it by having written about the figure of the foreign offender or foreign national offender. So the point then, the crucial point then, is the foreign prisoner crisis and the UK Borders Act and hubs and spokes in prison and all of that stuff. And Theresa May's kind of attacks on Article 8 and the CAT and the human rights and Richard Littlejohn in the Mail, all of that stuff. The figure of the foreign offender we can't deport, which includes the, cases like Abu Qatada's case. So again, blurs the kind of, discursively, not only legally, you'll see the blurring of the kind of Black gangster criminal and the Muslim terrorist or sexual offender as central to how the papers cover this. So anyway, I was interested in what policies had responded to that and what it meant that there were increasing numbers of people in detention who kind of had British accents and who had grown up here and were exactly all of these cases, you know, Lowe and CI and Akinyemi will all fit this description, although I don't know the individuals. So I was interested in that as a story before the Windrush Scandal, and of course the Windrush Scandal doesn't involve this, and quite a lot of effort was made to separate the issues affecting, you know, so-called Windrush migrants, again, who were sort of discovered. I know that we knew about the Windrush, but the category of a Windrush migrant as someone who arrived before 1973, to me, is not what Windrush migrant meant before the scandal. It meant probably more before 62. So already you've got this kind of, and I would say it's a sort of discovery of this particular group who have been harmed, and you have Jacob Rees-Mogg saying that this is fundamentally un-British, which plays into his Brexit kind of politics and line, which is, you know, the Mail's line on the Windrush is, look how, the way they could fold that into their own narrative is, look how absurd the immigration system is. We let these murderers off with, we let these people get away with murder, and we've got killers roaming the streets, many of whom probably people in attendance defend, all of the foreign criminal stuff. And yet the decent migrants, look at this person, they're the ones facing it. And so by having a kind of moral story about the good migrants and the bad migrants, you're able actually to talk about the Home Office's wrongdoing, but thread it back into a story about that they don't know, you know, British common sense is being assaulted by the wrong people, being targeted by immigration legislation. So I think that explains partly why the Windrush Scandal was both an opportunity and I think a good one. I think that anti-racists and migrant campaigners were able to have conversations where the hostile environment, which people had already been organising around, you know, when the Windrush Scandal came, you already had Docs Not Cops Against Borders for Children, you already had Unis Resist Borders, they already existed. So there was already a response to the internal borders that came with the hostile environment. But what you did get was a slightly broader conversation with some younger people, different people who didn't know about the law, didn't know about migrant policy, migration policy, being aware of this broader set of policies. And some of that was great, and some of that feeds into anti-racism in broadest sense. But there was definitely also a missed opportunity, because even on the, I don't know if even's the right word, on the Labour side, there was still a repeated emphasis on the fact that these Windrush migrants were citizens and they were not illegal immigrants, and that constant comparison, which is to say, again, to try and put people back in the right boxes, which is not my interest, and I don't think should be the interest of people who are committed in the long game to challenging this cruel system. It's not going to be fixed by you know, looking after one particular group. And you will remember that Sajid Javid said that anyone with a criminal record will not be eligible for my compensatory legal and financial promises to those who were victims of the Windrush Scandal. So, you know, illegal deportations aren't illegal if you commit a crime, which is striking, and I think tells us something about the overall political framing of these legal challenges, which is that that basically what the mandate for someone like Priti Patel, who is, you know, cartoonishly evil and committed to making political capital out of promising to make a spectacle of the punishment of all of these people, people arriving, people here, criminals, people who've been criminalized, is the underwriting that there's no real limit. And that, you know, the real worry for us, I think, when I was listening to some of this, is that even though the law is so complicated and we'd want to improve it, you know, the real worry is that by trying to get rid of some of these knots and strange questions over unduly harsh, that this government's interest is actually in simplifying immigration law in ways that don't benefit human rights or the things that we care about. So yeah, the Windrush Scandal was good to see, you know, the Home Office being labelled too harsh, but one has to be wary when the Mail and the Express are in line and Jacob Rees-Mogg and Brexiteers are joining the chorus, because that tells you something about how it can be folded into a story about Britain being welcoming for the right kinds of, you know, Britain is a welcoming place for refugees is the start of every political speech ever on immigration, and even though it's not true. So that's my caution. One of the things we do in the new book is to kind of say the Windrush Scandal was going on at this time, and at the same time, the other story on the inside of the pages was around knife crime. And so you can think, and I think that plays into the question of the foreign criminal versus the Windrush migrant, or just the black criminal, the black youth criminal. when compared with the Windrush migrant, is that part of this was saying these are respectable, decent, upstanding members of society, for now at least. Whereas, you know, the country's going to wreck and ruin, and we've got lost all sense of order, and that, you know, prison sentences aren't long enough, and build more prisons and bring in knife crime prevention orders and get rid of legal aid and whatever it might be, for those who are deemed to be criminal and endangering themselves and others. So yeah, sorry, that's a long way of trying to get at what I think was limiting and also hopeful about the Windrush scandal, and how the work beginning before Brexit just shows what we all know here, which is that these the reality of indefinite detention and deportation and family separation has been going on for longer and will continue to, in spite of the pathetic attempts at compensation for those Windrush migrants.
Thank you, Luke. Yeah, in terms of the Windrush, that's absolutely right. The Home Office has been quite clear and has been trying to lay the marks in terms of distinguishing the policies that apply to those who have convictions, and that has been maintained all the way through. But we know of some challenges that are pending. And I think, I suppose, we're probably running out a bit of time, but because we would like to leave some time for Q&As. But perhaps if I can ask you to sort of look down a crystal ball and predict what we might be able to look forward to, is with the courts grappling a bit more perhaps with the issues of integration, and the framing of that, and those questions being asked that you have touched on. Do you see that changing in the future in terms of what Black Britons face at the moment?
I mean, I guess I'd say that the struggle will not just be in the courts for these kinds of things. I know you mentioned in our pre-chat about the charter flight and the seemingly kind of silent agreement that that under 12 people who arrived before 12 or whatever wouldn't be deported to Jamaica or couldn't be deported. Not clear on what happened there. What I do think happened there is probably pressure on the Jamaican side. I think that
then from Jamaican authorities.
So the recipient state being pressured from public pressure from, again, Black Britons, from the fact that, you know, it's quite easy to get the Gleaner and the Observer in Jamaica to mention every time there's a charter flight. If Jamaica gets mentioned in here or the US, they'll cover it because they're a, you know, globally marginal kind of island. So that they hear when Jamaica gets named. So I think that that's been a deliberate point of strategy for campaigners and protesters around charter flights to Jamaica, which have been the most, you know, lively campaigns around charter flights, even though the Albanian and Pakistan ones get to go off silently. So that suggests to me that there's different ways to try and put pressure on, and that way seemed to, you know, the Home Office has dug its heels in and said, these are serious criminals. We want to be able to keep our operation going, and this has nothing to do with the Windrush. We're going to deport only offenders on the planes. And partly because of that, they end up with less people. And then lawyers, so-called activist lawyers, who maybe might embrace that label, maybe might not, for fear of losing their their freedom to act as independent from all of that, all of the political noise. But the acts of lawyers in relation to the flights and the campaigners do mean, I think, less people have gone on those flights, and perhaps the fact that the Jamaican government responded by saying no people who arrived as children because we can't deal with the public pressure around that, only people who arrived as adults. That has its limits, but of course small gains along the way. I'm worried, and I think we should all be, by this current government and by what Priti Patel and the rest are making of and trying to make of. They know that they won an election on Get Brexit Done, which is nothing really but an empty slogan for white nativism. And because of that, they're trying to play that card again to distract us all from the fact that, you know, 100,000 people have died from a mismanagement of this whole nightmare. So the cases in the South Atlantic and on the ferries and the floats in the sea and the Napier barracks and Penally and all of that plays into the followers of Tommy Robinson and Farage and all of that. And I think they know what they're doing. I think they know that the force of that energy, of that kind of culture wars discourse, will win them some support, and will distract people. I'm worried, I suppose, then that a question that the kind of legal questions that are quite specific about, say, integration or unduly harsh are incredibly important to fight back against and to find room for clients. And of course, that's essential. But the floor might get taken from underneath us if we don't build, if other people and anti-racists don't build power so that this government can't do that. I.e., what is really going to happen to immigration rules and to immigration law? Will they? At the moment, they don't seem to be doing anything, but will they at some point find political capital in changing all of that and in making it really hard to claim any human rights, and making deportation almost automatic like it is in the US or whatever, and just getting rid of all this complexity? And that's my fear. So that's the opposite to the hope on the one hand. And then, yeah, I mean, hopefully I think public pressure is really important. I think winning cases is, I hope that people campaigning and people protesting fuel lawyers and actually do impact judge. I mean, I hope that BLM and that some of these cases, the judges are people. One of the things I'm interested in about all this is the strange turns of phrase that they use, then create these kinds of knots in language that you then build on when you say, oh, they said homegrown criminal, or they said this, or unduly harsh creates all these questions. But anyway, the judges respond to, I think, public conversations. I think they do. So who knows how? It's hard to measure. But the racism which impacts black men in particular, who are the way in which judges talk about their inability to parent, or they're not cohabiting with partners, all of that stuff. Surely that can work the other way, where there becomes public pressure and all of these stories of deporting people who are born here starts to make judges and hopefully lawyers and barristers feel heartened that that there's some energy behind them. I don't think there's any concrete sense of how to build those links other than to say that changing the environment and the discourse can help, I think, somehow. Sorry if that's a bit vague.
No. And certainly judges are not enemies of the people. So I think we'll end on that note in terms of the Q&As. But yeah, thank you, Luke. Certainly food for thought, and some interesting comments in the chat box with, I'm sure, many in agreement. So thank you, Luke. If you have time, we can invite questions from the audience, if you have time to stay with us just for a little bit longer. What I might suggest is questions queued up in the Q&A box as opposed to the chat box, just to help my multitasking or lack of multitasking skills. And then second suggestion is, if you have a question specific to a specific speaker, it's a lot of specific speakers, do headline that. So if you've got one for Luke, and then put your question in the box, and perhaps those that have a question for Luke, put them in as soon as you can, because we may not have Luke for the duration of the Q&As if there are questions for our barristers as well. There are 2 questions in the Q&A box already, so let me just have a look at these. We have a question from Adeni Adewoye, sorry. Can we use these principles to apply to revoke a deportation order, especially the new unduly harsh principles in HA Iraq? So not directed at anyone, but it will be directed to Sarah, if you're happy to answer that. So whether the principles arising out of HA Iraq in terms of the new unduly harsh interpretation, so we say, whether that could be used for a revocation application.
I mean, I can see that Adin Ye has also clarified just below to say about those that perhaps have already been deported.
Exactly, pre-HA Iraq.
Yeah, so yeah, of course, those can certainly feature in terms of representations that you might make to revoke the deportation order, and also important then to look at impact that the deportation has had on the children, who have probably had to stay in the UK and then been separated from the parent that's been removed. So it's going to be again about trying to develop the evidence and to to outline that as clearly as possible, rather than just saying, look, there's been a change in the case law and we should succeed on that basis alone. It's probably not going to be enough. You're going to need to go beyond that.
Yeah. And certainly be prepared for a challenge.
Yeah.
Yeah, no, absolutely. And Luke, in terms, just taking that thread, in terms of your focus in the scenarios that you feature in your book, in terms of looking at where you feature 3 or 4 persons who have been deported to Jamaica, and you spoke to them in interviews and had updates from them and so on, looking at what you call sort of post-deportation outcomes, did you come across sort of efforts to reverse the action that they were the subject of?
You mean were people trying to get deportation orders revoked?
Yeah, I mean, not necessarily obviously take, you know, the legal aspects of their cases, but did you get sort of that sense that a lot of effort or energy was being spent in trying to reverse that once, despite it having happened?
Yeah, there was definitely inquiries, and I tried to help people. I don't know if people follow the rapper Cashtastic, who was removed to Jamaica. But anyway, he managed to get back. I mean, he had some more resources and support, but so people were trying. And you know, there was one person in the book who I approached, an immigration lawyer I know, and he was just kind of like, there's not really much chance. So there was a lot of me kind of naively wanting to help as well and work through some of this stuff and seeing which cases were that would be an option for, but it seemed pretty impossible and pretty hard. And I guess the other thing to say, which is kind of related, is that, of course, as a lawyer, what you're looking for is evidence that the person is really the effects have been especially damaging for the person and their relationships, and that deportation means that they actually, you know, that they can't actually reintegrate, and that the evidence so far is that they, you know, that they've found it impossible. Getting to know people over time, of course, you become invested in it being a bit more complicated than that. And in the book, I do kind of say in places, as an advocate or whether in legal context or in political context, you want to emphasize that people really might not survive. But when you're actually friends with someone over time, you want to give them space to be able to precisely survive and manage and find a way. So the book, yeah, the people who I knew, there were other people who, you know, one guy was shot at one point and was in hospital after trying to keep a low profile, and there was another barrister who was involved in his case, and then he, you know, went off the radar. So there were people for whom they were trying to. There were others who managed to get out of Jamaica and go elsewhere in various ways, legal or extra legal. It's not my position to comment on, but
no, of course, yeah.
But yeah, people tried to find ways. The guys in my book project, at least, that didn't seem like an option, and it doesn't seem like an option still. And I guess that's something you will all know about, how difficult / near impossible it can be to revoke deportation orders. And obviously, when I was there, the deport first, appeal later, there were quite a few of those cases, and none of them, you know, were able to appeal successfully, obviously. And you know, there was some organizing around that, and now it's not the law anymore, or at least it's been changed. I don't know the specifics of what is and what isn't lawful about after that Kiari bin lost thing, but yeah, that was ongoing as well. So there was that as a question.
Yeah, no, it changes a lot, and yeah, immigration law is yeah, forever changing. Good business for lawyers, but still gives us a headache. And so we have another question, thank you, Luke, for, I think, Sarah. Again, does the unduly harsh principle in HA Iraq also apply to spouses as well as children?
Yes, Jerome, it does, although the sections I've highlighted have been primarily focused on what KO had said about a child normally being affected or ordinarily being affected. It applies in exactly the same way to partners. Have a look at paragraph 53 of HA Iraq, where it's making it clear that it applies to the same level in both.
Super. I forgot to say earlier, Luke mentioned the report in terms of a sort of unofficial agreement for there not to be deportations from the UK to Jamaica for those who had arrived in the UK under the age of 12. So I did post the article that featured, it was Diane Taylor, in The Guardian in the chat box. Nothing is, unless Jamil and Sarah or Sarah correct me, I haven't seen anything since then to confirm anything more official, to confirm the remit of that, whether it was limited to that particular flight that took off in December, or that it's wider. But it is one update that may be worth keeping an eye on. I think perhaps in closing, I want to throw out a question from a colleague to all three of you, and see if we get different takes. But perhaps just a sort of from a lawyer's perspective and a non-lawyer's perspective, with Luke, where do you think the focus should be when we deal with Black Britons, having heard the way in which obviously deportations are being managed by the Home Office, how they're being challenged in the courts, and I use inverted commas for Black Britons just to make clear that it's the term arising out of Luke's book, but in the court arena it may be homegrown criminal, or obviously those that have been here since children, and to put it more neutrally in that form. Who wants to, I'm springing this on you, so I hope I won't be in trouble.
I mean, I'm happy to go first and try and thread it back to what I've covered. And actually, it also connects to something that Luke said, and it's really the importance of language and the words that we use. I mean, we have all these legal terms, and as Luke said, we all get tied up in knots about what they mean, and we can use that to our advantage in many ways, because there's a spectrum within all of these terms that we can use to the benefit of our clients in appropriate cases. And at the same time, words can sort of hide the truth of what's going on, and that's why it's important to sometimes use the emotive language like homegrown offenders or exile, and call a spade a spade. If you're saying that somebody that's been here since childhood should go to a country in which they've never lived or they've got no memory of, then you should call it out and say what it is. But for all of us, particularly as lawyers, we know this. We have to use the right words, and knowing the authorities, because deportation cases just have this trend. You win in the first tier, the upper tier overturns a decision, and the Court of Appeal issues a decision. We know our authorities, but staying on top of the authorities, as we're trying to do, and using them in the first tier to win, it is basically the best way that we can do it.
Yeah, I also think that trying to kind of work collaboratively as well. So events like this, where you're able to try and get as much kind of of an opinion piece as possible, and then trying to use that strategically going forward, because the odds are stacked against us, sadly, and these are very difficult cases. And as Jamil says, you get a victory in the first tier tribunal, it is going to be appealed by the Secretary of State, and let's hope that the recent Court of Appeal cases are going to make the upper tribunal a bit more hesitant in just overturning everything. But yeah, we'll have to wait and see.
Yeah, thank you. Absolutely.
Yeah, it's a good question. I mean, I'm the non-lawyer, so I mean, I think I'm not saying this in a kind of facile way to say, lawyers have to work within the law, and therefore some people, another strategy is to kind of work to try and radically change what the system that we operate under is. That's not to say that is superior to, in its effectiveness, to legal work, but it is to say that that winning these kinds of cases is incredibly important, but the broader struggle, hopefully, is what can make all of our lives easier when it comes to not having to basically, I mean, I don't know if lawyers talk about how they feel about these cases, but when I do expert reports, I feel pretty drained after that day of reading through someone's witness statement from a 7-year-old daughter or from a partner, and the way people try to speak in the language of the courts and make themselves legible to a judge. All of that just feels pretty horrible to me. So my interest is in trying to find some sort of solutions where people are able to not be basically, you know, detained indefinitely and forced on a plane in waist restraint away from their family forever. And part of that is winning cases and is being strategic with litigation and is good lawyers speaking to one another and is, you know, getting more legal aid and all of the difficult work that goes into that. And of course, is definitely not the cowboy kind of lawyers who some people engage with and get false promises from about how easy their case is going to be to win and it'll only cost $2-3 grand or whatever it is. But yeah, I mean, obvious points like broader fight for legal aid. I'm interested in what kinds of support are available for appellants going through it all, because they might win one stage and then it'll get bounced up to the next stage like you just described. I know that some groups do try and create resources for people to represent themselves or for kind of activists to support them. So, I mean, that's never going to be as good, but BID had that stuff after legal aid was cut for deport cases. Right to Remain have got their guides, and places like the Unity Centre and No Borders Collective have done some quite impressive, got some people out of detention, done bail apps and stuff like that. And then, of course, ideally, more legal aid, more community law centres. And then, I do think a broad struggle. I think that the most effective way to stop these kind of deportations in the long run might be that the hundreds of thousands of people who turned out on the streets against police violence start to see that one effect of that racist criminal justice system is precisely these set of cases. And to make those things harder to ignore and to see in separation, which is the immigration system and the criminal justice system.
Yeah, absolutely. A lot of that resonates, legal aid and so forth. So absolutely. I think we are going to, hang on, I may have been stopped by an additional question. So let me just see if there is another question. Yeah, there are two. Are we okay to take these two? Yeah. Okay, so let me just click on them. A question from, I suspect that is Mr. Taylor at Simcox Solicitors. Apologies if it isn't, but solicitor that I know of. Missed the Windrush webinar. We had a Windrush themed webinar on Tuesday this week. Where of a case where a person who was born in 1959 in the UK to Jamaican parents who were British subjects and had a British passport was effectively being denied his passport as he was required to prove that he was entitled to such a passport. I know it is not the subject of this current topic, but folds into the current narrative. So absolutely, I think that certainly touched on by you, Luke, in terms of those generations and obviously that having an impact, obviously for quite a few generations going down. The other question is directed at you, Luke. I saw from Renee Fickling, I saw a programme on the BBC in 2017, Don't Deport Me, I'm British, involving a young man called Francois sent back to Jamaica. Do you know what happened to him?
Do you want me to take the second one first? Because it's quite a short answer. Unfortunately, no, I don't. I did watch that programme, I think, but I can't remember the individual. Yeah, I wasn't in touch with kind of everyone who ended up back, and of course some people don't want to chat to a researcher or a journalist or whatever I might appear to be.
And in terms of the Windrush themed question, I mean, that's focusing on the difficulties of obtaining a British passport and is very much themed within the Windrush issues. But perhaps for Jamil and Sarah, I mean, am I right? Would I be right in saying that we could still be seeing persons facing deportation that may have Windrush type issues, or there may be legal issues like that haven't been picked up?
I know of one very historic Windrush style case that came past a colleague's desk a few months ago, and when she outlined the facts to me, I mean, it was something similar. Somebody that had been in the UK for almost 40 years, problems with documentation, and was now facing deportation for a criminal offence. And this person was in their 60s, or something like that now. And you know, it shocked me that this was even before the courts. I understand that the hearing went well. I haven't followed it up, but it is possible. It's very possible, and it's important for us as immigration lawyers to be on top of not just, you know, deportation law and the changes there, but all of this, Windrush, the policy, and that's why, you know, can I say that connecting with people like Luke is fantastic, because we all need to work together and learn from each other.
Yeah, absolutely. Okay, so I think we are there. And so you may have guessed we haven't been graced with Lawrence's presence for his talk this afternoon. So big apologies, certainly from him, that's been relayed to me, and from us for him not being able to make it. Lawrence was specifically going to speak about delay and its impact in deportation appeals, how that can be argued, arguably conflicting authorities on that. But as mentioned, we will postpone that, so it won't be lost, and it's something to look forward to if you have an interest in that. And so watch this space in terms of adding that to the series or a bit later on in the year. I have posted in the chat box both our Eventbrite link for Chambers that has all of our future events going into March. Our next webinar, we've got a break on Tuesday, but the next webinar will be next week, Thursday, on the 4th of March. Slightly different topic, so it's one of the joys of our job as immigration and public lawyers. We can move either from country to country or major issue to another. And so Thursday, it's our head of Chambers, Anthony Metzer QC, and Emma Harris on Hamid courts, regulatory issues. So for those who are not familiar, Hamid courts have become, it's become the term that we certainly use when immigration lawyers are either referred by the courts or there are some concerns in terms of conduct. And so they will try and grapple with those regulatory issues to help practitioners on that area. So you have the link in the chat box, and also a future event hosted by BID, Bail for Immigration Detainees, who will be hosting again a sort of evening with, or a Q&A session with Luke on his book Deporting Black Britons. It will be a longer event than we were able to have, so do book that if you are interested in finding out more. So on that note, thank you all three of you for joining us and for sharing your time and your expertise with us. I hope everyone enjoyed it as much as I did, and I hope to have you all again sometime soon.
Thank you.
Thank you.